Everybody back and ready? Defense counsel, is everybody from the team here, ready to go?
Yes, Your Honor.
Right, Lance?
Yes, Your Honor.
Everybody, my jurors, they ready? Welcome, scoring. Scoring's all clear? Yes. Everybody's ready and warmed up. Bench makes in their case. All your first statements.
Your Honor, before we proceed, may we please request a time check?
Absolutely, sorry. Yeah, time keeps rise each and time makes you on the same page.
Plaintiff has 26 minutes, 43 seconds, and defense has 36 minutes, 47 seconds.
Your Honor, the defense has the same time.
Right, thank you. When you're ready, call the first witness.
Thank you, Your Honor. At this time, the defense calls Drew Cantrell to the stand.
So when this has been constructively sworn in, you may begin your questioning when you're ready.
Good morning, Mr. Cantrell.
Good morning.
Could you please introduce yourself to the court?
Yeah, of course. My name's Drew Cantrell, and I've been born and raised in Pascal, Ontario.
And what do you currently do for a living?
Currently, I'm the firearm safety instructor of Shooting Star Gun Club.
Were you always a safety instructor at Shooting Star?
No. Prior to this, I was the store clerk of Shooting Star.
And how did you get that initial job as a field clerk?
Well, one of my visits to Shooting Star Gun Club, I saw a big help wanted sign. Now, I'm the only unemployed friend of the friend group, so they all thought it'd be great if I got a job. So I went in and I asked for an interview.
And what happened after you asked for that interview?
Skylar Coleman, the manager, granted me one, and we talked for about an hour.
And what was the interview like?
Quite formal. He took things very seriously and was a very stern man, if I'm being honest. At the end of it, I signed a few papers as well.
And did he ask for anything specific during your interview?
He did. At the end of the interview, he asked for my license as I was signing a few papers. So I think it may have been a background check.
What happened after the interview?
After the interview, there was about a 2-week waiting period when I got told I got a job.
And after you got the job as a sales clerk, how was your time at Shooting Star?
Well, it was great. I really love the community as I go as a customer all the time. So to be able to see my buddies as they're checking in and talk to new people was a really wonderful experience.
After you had that wonderful experience, were there any other experiences that you had at Shooting Star?
Unfortunately, there was one mistake I made as a store clerk. As I was inspecting a gun, Skylar Coleman suddenly comes running over to me, and they were very stern in their appearance as always, but their words were just as hard. They had told me to stop doing what I was doing as I was inspecting the gun.
And how, if at all, did that change your experience at Shooting Star?
Well, Skylar Coleman runs their business as a very tight ship. I did not want to be on their general blacklist, and I really do pride myself in putting the best work forward. So I really listened to them, learned, and grew from this experience.
Now, earlier you mentioned that you went from the position of a safety instructor, sales clerk, sorry, to a safety instructor. Could you tell the court more about that process?
Yeah. So while the sales clerk position was really great, to be quite honest, I thought it was a bit below me. This may have been one of two jobs I held, but I still wanted more. So I was going after the safety instructor position. I'd gotten a safety certificate in preparation for it, firearm offender.
After you got the certificate, what happened?
I expressed interest in Skylar Coleman as I really did want that job. At the time, though, there was not a vacancy in it. However, as time progressed, there was. So I told them once more that I wanted the job.
And what happened after you told them that you wanted the job?
They looked over my qualifications, saw that I had a firearm safety certificate, but just told me that they also wanted a firearm instructing certificate. So I acquired that, and they deemed me well qualified for the job.
What happened after they deemed you well qualified?
I was hired for the position, and I began training and instructing new gun owners.
And how was your experience at Shooting Star as a safety instructor?
It went quite well. There was one incident that I did have as the firearm safety instructor. However, it did not occur while I was teaching a lesson.
Could you please elaborate more on the incident? What happened?
Unfortunately, I forgot to unload a gun as I was bringing it back in the lesson to the store front. Skylar Coleman saw this, and while there was no one in the store, they still were very mad. I mentioned once more that they do run a very tight shift, so any potential violation of the rules are taken very seriously.
How, if at all, did that change your experience at Shooting Star?
This really was a position that I enjoyed. To be able to instruct others, just like how my dad instructed me on how to use a gun, was just something I really loved. I didn't want to disappoint Skylar Coleman, and I didn't want to disappoint myself, if I'm being honest. So I really listened to them once more, and I learned from this experience quite a lot.
And after this incident, were there any other incidents?
No. After this incident in particular, I did go forth with a new mindset. I made sure that all the lessons I taught were to the best of my ability, and from what I heard, I was doing pretty well.
As a safety instructor, did you have any more incidents inside the ring?
No, I never had any incident inside of the range, actually.
I'd like to move on to the incident at trial, which is May 28th. Could you tell the court about what you did to prepare beforehand?
Of course. In preparation, as I was talking to Skylar Coleman, I got the general understanding that Justice Carbo and Nick Allred were new to guns. With this understanding, I really made sure to emphasize throughout that lesson more basic safety points, given that they may not have been aware of them.
What happened after you emphasized the basic safety points?
I gave them the safety equipment that is standard for my lessons, goggles, earmuffs, and I told them that I'd be running them through the basic rules of gun handling, as well as at the end of the lesson, demonstrating how to shoot one.
I'd like to move on to that part about demonstrating how to shoot a gun. Did you give them any specific instructions before you did that?
I did. Beyond informing them of the safety rules, I told them to stand specifically to my direct right. I wanted them to be able to see how I was shooting, as I am a righty. And so I told Justice Carbo to stand directly to my right, and Nick Allred to stand to their right. Close enough that they could see, but far enough to make sure that they wouldn't bump into me or flinch.
Would you recognize where this if I showed it to you?
I would.
Let the record reflect I am now approaching opposing counsel with what has been pre-marked as Exhibit 2G as a result. Could you flip to that exhibit in the
Of course.
Is this a fair and accurate copy?
This is, yes.
Has it been changed or altered in any way since the last time you seen it?
No.
At this time, the defense moves to enter Exhibit 2G.
Any objection by plan? No objection, gentlemen. Okay. Everybody is so entered.
Your Honor, may I give the jury a Mr. Cantrell, what do the X's on this exhibit represent?
The X's represent where myself, Justice Carbo, and Nick Allred were standing.
And are the X's positioned in a way that follows your instruction?
Not directly, no. I told Justice Carbo to stand to my immediate right, and this is a slight deviation from that.
Well, if it was a slight deviation from that, why didn't you correct this recording?
At the time, I was getting ready to fire my first shot. Now, as the firearm safety instructor, I always pay attention as to how I'm holding the gun, making sure that any habits I potentially have when I recreationally shoot don't translate to that of when I'm instructed. So right as I was taking my first shot, I was focused on making sure that all else and all other rules were followed.
Thank you, maybe that would be all. So now I'd like to move on to the moment the gun actually fired. What happened?
Well, as I fired my gun, I fired one shot and one shot only. I had my vision slightly obscured by the safety goggles, so I didn't notice that Justice Carbo had moved closer as I was firing my first shot, and they suddenly bumped into me.
What happened because Justice Carbo bumped into you?
Now, already, the gun had some violent recoil. I by no means am a stranger to recoil, but the recoil was very, very strong. I prepared for this and was about to shift my hand when, as I was being bumped into, the recoil, combined with Justice Carbo's movement, made me lose all control of any shot that was fired afterwards.
What happened because you lost all control?
Because I lost all control, Justice Carbo was sadly injured. And I feel terrible, but it really was just a tragic accident.
What happened after May 28th?
After May 28th, Justice Carbo had sued me. And I was still retained. However, I went forth with the understanding that even though I taught this lesson, as I taught all my other lessons, it wasn't exactly my fault. The lesson wasn't like the other one. It had Justice Carbo in it.
Thank you, Your Honor. No further questions.
Thank you. Then ready for your cross-examination?
Yes, Your Honor.
See when you're ready.
Mr. Cantrell, I want to begin with your fitness as a firearm safety instructor. Prior to working at the defendant's, you never worked with a firearm safety instructor anywhere else, correct?
No, I have not.
And not only have you not worked with a firearm safety instructor, you also have a history of not following safety. Is that right?
No, not exactly.
You would agree with me that traffic laws are put in place to ensure that safety.
They are, yes.
Your Honor, I'm showing you where you come to 21. Question the witness.
Mr. Cantrell, in Exhibit 21 that I just handed you is your criminal record, that's correct?
That is correct, yes.
It's an accurate copy of the criminal record.
It is an accurate copy.
Your Honor, the plaintiff offered Exhibit 21.
Is there objection by the defense?
Yes, Your Honor. More prejudicial and probative. Would you like me to elaborate? More specifically, the contents of this criminal history do not have any relation to the job that Mr. Cantrell applied for, which is a sales clerk, and therefore it only serves to mislead the jury by having them assume that criminal history has something to do with negligent hiring, which is one of the charges today.
What's your response, sir?
Your Honor, this is highly probative to the jury, as this is a negligent hiring and retention case. And one of the prongs that the plaintiff must prove in today's case is that Shooting Star Gun Club either knew or should have known that hiring Mr. Cantrell was reckless and was negligent. And Your Honor, a criminal record showing past instances of conduct where he has violated safety rules is highly probative to the jury when Shooting Star has hired him and either knew or should have known about the criminal record prior to his hiring.
Your Honor, may I respond?
Please.
Nowhere in Imperial law says that because someone has a criminal record, that makes the employer have negligent hiring. And thus, this exhibit only serves to prejudice the jury.
I agree. Objective sustained. The exhibit is not exhibited.
Thank you.
Yes, Your Honor. Sir, prior to being hired by the defendant, you had just been fired from your previous job for being drunk on the job, that's correct?
I myself was never drunk on the job. However, it was alleged by my employer falsely that I had been.
Regardless of that, sir, the defendant never asked you why you left your previous job, that's right?
No. Throughout that hour, all of the questions were really geared towards who I was as a person and my firearm experience.
Just to be clear, that's a yes, he never even mentioned your previous job, right?
That is correct.
And even after you were hired by Shooting Star, your unsafe behavior continued, right?
No, never did I intentionally try to be unsafe, and I really do pride myself on excellence.
If you could put to exhibit 8 in the exhibit binder,
Of course.
so you know. Are you there, Mr. Cantrell?
I am hardly there.
Sir, at the bottom of exhibit 8, you were aware that it said that failure to abide by the rules might result in removal from the facility or denial of future shooting privileges. You were aware of that, that's correct?
I am aware of this now, yes.
Is it your testimony that you were aware of this now, or that you knew this while you were working at Shooting Star Gun?
I became more aware of this of the latter half of my time at Shooting Star Gun Club, as when I was a store clerk, all of my duties were really in the front of the shop.
Just to be clear, when you were working as a firearm safety instructor, you knew about the consequences of breaking gun safety rules, that's right?
I did, yes, and I was responsible for enforcement.
And you knew about the rule, the violation specifically in exhibit 8, posted on the wall at Shooting Star, that's right?
Yes, on the gun range.
Now, in May of 2021, you violated the second rule on this list when you aimed a firearm at another person in the shop, that's correct?
That is incorrect. I never pointed a gun at another person. I've been around guns my entire life, and that was the first thing I was taught.
Well, sir, the defendant's owner walked into the room and said, Mr. Kinchell never pointed a gun at another person in the shop. We don't do that here, that's correct?
That maybe have been what he said, however, he wasn't there to see it, and I never did that.
Just to be clear, he even wrote you up for that incident formally, didn't he?
That is correct. As I said, he's a very stern man and takes his business very seriously.
Well, you say he took it seriously, but Mr. Kinchell, you were not removed from the facility.
No, I was just a store clerk at that time.
You were not denied any future shooting privileges?
No,
And just 3 months later, you were promoted to firearm safety instructor, is that right?
I was. As I mentioned after this incident, I really did take time to listen and learn.
So you say you listened and learned from it, but just 3 months after you were promoted, you broke the fifth rule on this list. You brought a loaded gun out of the shooting range and into the storefront, breaking the rule on this list, that's correct?
That is correct.
And just to be clear, sir, you were not removed from the facility, that's right?
No, this was my one and only ever mistake made as a firearm training instructor.
So just to be clear, you were written up for both the May 21 incident and the November 21 incident, that's right?
I was. However, the November incident was the only incident that happened when I was the firearm safety instructor.
But regardless of that, Mr. Coleman, the owner of Shooting Star Gun Club, wrote you up for both of them, that's right?
That is correct, yes.
And neither time were you removed from the facility or denied any future shooting privileges, that's correct?
That is also correct, yes.
So I'd like to turn our attention to the day in question, May 28th of 2022. Now, this is the first time you had ever met Mr. Carter or Miss Carter, that's correct?
It was, yes.
You picked up her brand new Glock 22 and you brought it into the shooting range, that's right?
I did.
Just to be clear, sir, it's your testimony that that gun fired with fierce, violent, unexpected recoil, that's correct?
Not unexpected recoil, but much more violent recoil than anything I've experienced.
That's right, sir. It's your testimony that that violent recoil was the first step in the chain of events that resulted in my client's injury, that's correct?
Yes, it was.
So you would agree with me that the function of a gun is to fire it, wouldn't you?
That is the purpose, yes.
You would agree it's the function of a gun?
Yes,
And the only way to test that the gun is functioning correctly is to fire that gun, right?
that is true, yes.
Just be clear, sir, you did not fire my client's brand new Glock 22 before you started teaching the training course, is that right?
No, I have not.
And just to be clear, that breaks the seventh rule that we see in that summary.
It does not, given that the check your weapon is more in terms of ensuring that all working parts of the gun are functioning. And more often than not, as safety instructors, we do often just fire new guns.
Just to be clear, sir, this rule says, make sure your weapon is functioning correctly, right?
Yes, as I was doing so throughout the training course.
So you decided to test if the gun worked properly after you had already began the training course with two people next to you?
It was not a proper checking, given that the Glock 22 has always been a reliable weapon. And with that understanding, I used it to demonstrate.
So just to be clear for the jury, you assumed because you had used Glock 22 in the past, that this brand new Glock 22 that my client purchased would be the exact same, and therefore you didn't test it?
That is true, yes. I, in my experience, thought that if the Glock 22 were to malfunction, I would be able to compensate, such as the violent recoil. I would have been able to compensate if Justice Carbo had not bumped into me.
Just to be clear, sir, if you had tested that gun before beginning the training course, you would have been aware of that recoil, right?
I'm unsure if the violent recoil was just cause of the gun or maybe faulty ammunition, so I can't be sure.
Just to be clear, sir, if you had fired the gun before, you would have been comfortable or you would have been prepared for how to fire it, right?
Yes, but I'm not sure if I would have known about the violent recoil.
Well, sir, if you had fired the gun prior to beginning the training session, then you would have been prepared for anything that would have happened with firing that gun, right?
I believe so, but once more, I don't know if it was the actual ammunition or the gun that had the violent recoil cause.
Is it your testimony that you believe the ammunition might have been faulty in this gun?
No, I'm not claiming that it was faulty ammunition. I'm simply stating that I don't know why there was such violent recoil.
And just to be clear, the violent recoil that you didn't know about because you did not fire the gun prior to the training session was the first thing that happened. in the
Objection,
chain
Your
of
Honor.
events.
Argumentative.
What is?
The simple fact that opposing counsel is saying argumentative, in their question.
Can you respond?
Yes, Your Honor, I don't believe this is argumentative. I'm just trying to make sure I lay out the chronological events for the jury's favor to understand what happened.
Okay, I'm gonna sustain the objection, just to allow you to ask another question so we can clear in terms of the. Fine?
Yes, Your Honor. Sir, just to be clear, you did not fire the gun before, but you were not aware of how the gun fired. As you said earlier, the harsh and violent recoil was the first thing that happened in the chain of events before my client was injured, that's right?
It was a factor that had exacerbated the impact of Justice Carbo bumping into the head.
And if you would have fired that gun before the training course, you could have known about that recoil, right?
Yes, but no one could have predicted Justice bumping into
Thank you, Mr. Kenshaw. No other questions.
You read it right?
Yes, a review.
Yeah.
Mr. Cantrell, I'd like to redirect your attention back to Exhibit 8. Where do the safety rules apply?
They apply specifically to the gun range, which is why I wasn't quite familiar with them when I was in store clerk.
And going back to your two incidents in May of 2021 and November of 2021, where did they take place?
They both took place in the general storefront, one when I was the store clerk, and then one when I was the firearm safety instructor.
So just to be clear, these incidents did not take place in the gun range.
No, both incidents happened in the storefront on two separate jobs.
So do these safety rules apply outside of the gun range?
While they're generally good practices, the actual punishment for them only apply within the actual range of which I enforce.
Thank you, Your Honor. No further questions.
Thank you. You read it right?
No question.
No? What is excused? Your Honor, no. Yes, you're excused.
Thank you.
Thank you for your time.
Thank you, Your Honor.
Come to call the second, witness, please.
Yes, Your Honor. At this time, the defense calls Avery Nguyen to the stand.
Witness is constructively sworn in, you may begin your question.
Good afternoon. Would you introduce yourself to the court?
Good morning, my name is Avery Nguyen.
Well, how did all your training for?
I currently interface with multiple European-based companies as well as some companies on the East Coast.
What, if any, personal experience do you have with firearms?
From a young age, I've been fond of them, not only as a hobby, but also as a way of connecting with friends and family. Even to this day, some of my closest friends have been from the family community.
And how's that experience translated to empirical?
Well, times were tough during college. I fell out of college. However, once I secured a job and delivered a disposable income, I began to get back into collecting. All purchased from Shooting Star Gun Store in West County.
What's your relationship with Shooting Star Gun Store?
Well, it's really been like a second. Their community is simply stellar. With the addition of their new farm cafe, I've been able to make connections with so many others, even outside of the gun community. Their owner, Skylar Coleman, has even been kind enough to offer me to install it when I come into my guns. I'm proud to say it's become to them among the regulars as Avery. He's helping the community has always been what I care about most.
What's your experience in purchasing guns then?
Well, from my experience, it's been extremely thorough. From the moment I was beginning to attempt to purchase it, Shooting Star and Cody would come with running a background check and enter my data into some kind of spreadsheet. Then they would offer me a complimentary safety to go with my purchase. The only one who didn't do this was Coleman, but being one of his most loyal customers, as well as one of the most prominent shooters in the business, I wasn't really surprised. And this is all about talking about the security they have at the range.
Security at the range? What security do they have there?
Well, for one thing, they had range security officers posted everywhere. They were remarkably efficient at correcting violations as well as assisting customers.
Objection, Your Honor, improper opinion. Mr. Lloyd is not qualified to assess the efficiency with which security officers at a gun range take care of security issues.
Response, Your Honor, if I may, my witness is simply testifying to the speed at which they're handling their operations. Efficiency as a function of how many tasks they're doing per second. It's not expressing an opinion on the quality of their work, but rather the timeliness with which they conduct their work.
We'll hear from you one more time.
Your Honor, this is assessing the quality of their work. He said they weren't efficient. If he wants to say how many things he saw them do in a given period of time, that's appropriate testimony. But whether or not he thinks security is doing a good or efficient job is both not relevant and improper.
I agree, sustained.
Now, Mr. Nguyen, did you observe the Shooting Star employees do their job?
Yes, I did. They were remarkably efficient at helping. They were quite good at helping newer customers as well.
And so you talked a little bit about the customer side. So what's your experience thing with Shooting Star's management?
The Coleman family has done an excellent job managing the shop over the years. The one point I will note is the improvement on safety, especially within the gun range. In the past, there have been
Objection, Your Honor. Again, Mr. Nguyen is not qualified to assess the safety of the gun range or improvements of that safety, or whether or not the gun range is being run, quote, well.
Your Honor, if I'm proper, specifically, my witness is only going to testify about a reduction in number of reported incidents. Specifically, he's not talking about the actual safety of the range, but rather his experience observing safety incidents at the range. What have been reported safety incidents by Shooting Star. He's not testifying to that specific fact of the safety.
Your Honor, Mr. Nguyen just testified that the Coleman family is doing a fantastic job running the range, particularly with regard to safety. This is an improper opinion. If he wants to specifically address reduction in the number of reported incidents, that's fine.
Agree, sustained once more.
Now, move to strike that testimony.
Right.
Now, Mr. Nguyen, anything that you observed about safety incidents happening at the
well, in the past, there have been some incidents with newer customers improper guns in the range. Well, these incidents were nothing serious. Well, when newer employees started filtering the shop, these incidents started to decrease in number.
Now, let's talk about the events of May 20. Where were you?
Well, on that day, I was posted up at a table behind the stall, Avery's counter. just working on some customizations for my lever action rifle. Now, the training and clutching was happening 2 stalls down, stall 11, but on the day of clutching, there was no one at any of the stalls in between.
You mentioned training. What specifically are you referring to?
Well, first I heard of this training was when some kid, Nick Albert, wandered up to me and asked me if I knew about safety training, which was happening. I'm not doing the company's daily plans or anything like that, but I recognize what he described as the typical gun safety kit that's offered by the company, and I directed him to stall 11, where he said it was happening. About 15 minutes later, a control walked with someone who I was introduced to as Justice Carver, started up to the left.
What if anything happened when the gun license started?
Well, to begin with, it was all safety essentials, so all stuff I was already familiar with. I'm familiar with all levels of safety protocols, so to me, it wasn't really anything groundbreaking. At the time, absolutely nothing seemed out of the ordinary. It was when Cantrell started the demonstration section with the gun that things seemed to take a turn.
What happened when Cantrell started the demonstration portion of the work?
From my perspective, Cantrell was closest to me, Carbo to his right, and all right the furthest. The first thing I noticed was that Carbo appeared to be crowding Cantrell from the right when the demonstration began. What happened next was a whirlwind.
Objection, Your Honor, under Rule 403, it's substantially more prejudicial than probative, saying that Ms. Carbo was crowding Mr. Cantrell. It is an assessment of the safety of the situation. Which is on,
Your Honor, if I may, I believe this is a visual observation about the condition of the circumstances. He's not making an opinion as to safety. He's not saying, if I may, Your Honor, he's not saying that because he was crowding when it made the situation more unsafe. He's merely observing a physical fact about the situation.
Agreed. Overall,
yes, sir.
So, Mr. Nguyen, what then happened after Carlos started you observed Carlos fighting?
Well, 2 shots rang. The first shot went off without a hitch. There were no issues aiming, no movement or shot, and it was generally on target. Second shot, though, that was a different story. Immediately after the first shot, I saw Carbo jump and bump into Cantrell. Obviously, Cantrell's arm swung, he dropped the gun, and the second shot went off sometime before or after he dropped the gun. That second shot is the one that made the Carbo. I was honestly shocked, since I had never seen anyone get hurt like this before shooting star.
What if anything happened after the shots were fired?
After the shots, I heard Coleman shouting from the shop for someone to call 911. Minutes later, the paramedics arrived. They took Carbo on the stretcher, wheeled him out of the shop, and by that point, it was over.
Thank you, Your Honor.
Johnson, you need to cross when you're ready.
Yes, sir. Mr. Nguyen, based on direct examination, it's safe to say you're a pretty experienced firearm.
Yes, I've been coming to shooting star for a number of years now.
And safe to say that you're familiar with the basic ground rules of how to operate a gun safely.
Well, I would say so, yes.
And as you just said, you spend just about every weekend shooting stuff.
I can't say. I try to get out there about once a week just to make conversations.
So you're familiar with the list of rules posted inside you. aren't you?
Yes, specifically in the gun shooting.
The reminder of YouTube is a date. Sorry. Now, as a safe and experienced firearm user, you adhere to, don't you?
Yes, all the time.
You do so because it's unsafe, not. Right?
Yes. that is correct.
Objection, Your Honor, specifically as to the nature of the rules as they apply to safety. Whether or not this witness is experienced in gun safety, hasn't been tendered as an expert, and we have 2 legitimate gun safety experts who have been offered in trial today to offer opinions on these kinds of.
Agreed. Sustained.
Sir, you do abide by. Right.
Yes, as I stated.
Now, I want to talk to you about something you saw in Mason. You saw Drew Cantrell pointing a gun. Did you?
Specifically, yes, I did see the incident itself, but I was not aware of any of the circumstances that led up.
But regardless of the circumstances, you saw Drew Cantrell pointing a firearm at another person.
Specifically, yes, I did see the incident itself, but again, none of the circumstances leading up to it.
So you don't know if it was fighting. Right?
I would have no way of knowing.
You also don't know if he was just joking around.
No, I again, have no way of knowing.
All you know is that you saw the gun.
Yes, that is correct.
Sir, this violates Shooting Stars rules, doesn't it?
Well, yes, it violates the rules of the gun firearm.
Yes, it violates both the rules of the range and of the store.
Yeah.
And not only the store, but also a basic rule of guns.
Objection, Your Honor. But once again, asking this witness to testify to basic and essential rules of gun safety.
If you want time to as I was allowed to. Rule number 2. Only point at it if you want it destroyed. Always keep the gun pointed downrange and never point a gun at anything you are not planning to shoot. Did I read that correctly?
Yes, you did.
So pointing a gun at somebody you're not planning to shoot, that's a violation of this rule.
I would say so. Again, it says downrange, which specifically refers to something you would be doing within a gun time limit. But yes,
Now, if you see at the bottom here, it says failure to abide by the above rule may result in removal from the facility and denial of future shooting privileges. Did I read that correctly?
yes,
Now, to the best of your knowledge, Drew Cantrell was not removed from the facility following the May 2021, correct?
no, but again, it says may result, so it doesn't necessarily state that they will be, or they will lose privileges.
And to the best of your knowledge, Drew Cantrell did not lose those privileges.
No, I'm not with you.
Instead, about 3 months after this incident, Skylar Coleman decided to promote Drew Cantrell. correct?
Yes, you started to teach gun safety lessons.
Thank you. You redirect?
No redirect, Your Honor.
What did we do there? That's been close next witness. Any further?
Yes, Your Honor. At this time, the defense calls Ms. Jackie Staub.
The witness is instructing sworn in. Please begin your questioning.
Thank you, Your Honor. Good afternoon. Please introduce yourself for the court. Hello, my name is Jackie Staub. And how about are you employed? I'm employed in my firm, Staub Examiners LLC. I'm a firearms and trademark examiner specializing in firearms operations. You mentioned your firm. Could you please describe it for us? Of course. We specialize in firearms technology. And as the founder of Staub Examiners, I have a dedication to ensuring that every person has thorough and proper access to safety training. And through that dedication, we can provide the safety training courses here in Florida. So what kind of educational or background experience do you have in the field? Well, I received my bachelor's of science in physics from the U.S. Military Academy at West Point with a minor in economics. Afterwards, I served for around 7 years in the military as an artillery officer, during which time I was qualified as an expert people chef. Do you have any other special certifications? Yes, I have received gun safety certifications from both Imperial and Department of Justice, as well as the U.S. Bureau of Alcohol, Tobacco, Firearms, and Explosives. I was also deemed a distinguished expert in rifles, pistols, and shotguns by the National Rifle Association. So, Ms. Staub, how did you become involved in today's case? I was retained by defense counsel in November of 2022 in the case of public proceedings LLC on best practices for firearm use in CF. I was consulted for an expert analysis and conclusion on 2 matters. Firstly, whether or not Mr. Cantrell's handling of the gun on the main question was following industry practice. And secondly, whether or not shooting startup for sale of the gun to Mr. Carbo was reckless such that it violated the statute. And are you being compensated for your work on this case? Yes. I'm charging the standard rate of $350 per hour for my analysis, as well as a flat fee of $500 for my testimony here today. In your analysis, did you analyze means or methods commonly relied upon in your field to come to a conclusion? Yes, I did. And what kind of materials did you look at?
I reviewed the comprehensive documentation and evidence provided to me by the defense counsel, drawing from my own education and experience, as well as that of individual education. I also cross-referenced with industry standards to form my.
At this time, the defense moves to enter Ms. Staub as an expert in firearms mechanics and operation, as per the stipulation.
Okay, this is stipulated, so this is not objected, correct?
No objections, Your Honor.
Move forward.
And at this time, the defense would also like to invite Ms. Staub to the well to make use of a pre-approved demonstrative for the jury.
Any objection to the demonstrative? That's fine.
No objection, Your Honor. I just asked that they move to see the demonstrative.
Right.
And members of the jury, Your Honor, is this demonstrative able to be viewed?
Well, the council's going to reposition it.
So, Ms. Staub, when you started your analysis in this case, what did you first look at?
Well, as for my specialization, I looked into the actual weapon being used, which I found to be it's fairly simple for my own.
So, do semi-automatic guns have any unique features?
Yes. So here's a diagram of a semi-automatic gun, like the Glock 22 in question today. Now, semi-automatic guns combine aspects of both manual and automatic guns such that they do not require the operator to manually place the rounds in positions before firing. They also do not allow for more than one round to be fired at a time. Third, semi-automatic rifles also come with front stock. As the nature of semi-automatic weapons as a whole is to have its indicated recoil. Thus, the operator using a semi-automatic weapon should intend to stabilize its recoil using a proper stance, releasing their finger from the trigger, and allowing a new round to enter the chamber after it's fired.
So, based on this information, did you come to any conclusions about what happened on May 28th?
Yes, I concluded that the cause of the misfiring on May 28th was actually due to the mechanic.
And could you explain what you mean by that?
Of course, to clarify, this paradigm has an unusually light trigger, meaning that the force to the pressure trigger and fire the gun is less than 100 volts. Any other handle with stronger trigger will not have fired from the operator's finger rest.
Thank you. I'm not done with this demonstrative, and you may leave. So, Ms. Staub, you mentioned that the trigger played a part in what happened on this case. Did you look into any other causes to explain the incident?
Yes, I looked into Mr. Kenshaw's handling of the gun on the day in question to determine whether or not it followed industry patterns.
And did your analysis consider any factors of preventability?
Yes, I also examined shooting star gun code 6 of Block 22 to use this cargo to determine whether or not it was reckless under Imperial Book of 2007. Now, this law actually has two potential applications in this case. The first of which being shooting star gun code's entrustment of the Block 22 to Mr. Control as an instructor, and secondly, shooting star gun code's sale of Block 22 to his cargo.
So, based on those two applications you just mentioned, how did you go about your analysis?
Well, there were two main things I got in mind. That isolated incidents in the past are not a determinant of a person's ability to use a firearm. And secondly, that the incident itself is also not evidence of a person's fitness to use a firearm. All that is relevant is the shooting star gun from used prior to the event on May 28th, and thus hindsight bias has been factored out of the.
And what did you find?
I found that Mr. Fairchild had extensive experience with firearms dating back to his childhood. He had only had two gun-related incidents over more than 2 decades of handling firearms, which is impressive. Neither incident involved the discharging of firearms injuries or was repeated in any sense. And additionally, Mr. Fairchild has also received a firearms safety certificate as well as a firearms instructor certificate by the Imperial government. Thus, I found that Mr. Fairchild has extensive experience in firearms.
Ms. Staub, how about the day in question?
Well, evaluating the sale of Block 22 Mr. Cargo or Miss Cargo, I evaluated two things. Firstly, whether or not the gun sold to Miss Cargo was suitable for her level of experience in handling firearms, and secondly, whether or not she's properly trained in the handling of the firearms.
Based on that, what did you find in your analysis?
I found that Mr. Coleman provided all proper safety checks and offered a safety training course to Miss Cargo prior to the sale.
So, Ms. Staub, based on your analysis of this case, what would you overall conclude was the cause of the incident on May 20th?
I concluded that the cause of the misfiring on May 28th was due to the gun's overly sensitive trigger, as there was proper operation being exercised on Mr. Control throughout. Students are properly entrusted the firearms to a certified safety instructor, who has carried out an proper safety course with a gun that was suitable for public use.
Objection, Your Honor, and proper opinion.
Yeah, please.
Your Honor,
Ms. Staub here is with tenure as an expert in firearm operability, not in firearm safety. So it's improper opinion for her to testify to the safetiness of the course that was being offered that day.
Your response?
Your Honor, my witness is simply providing context in her conclusion by stating that because she found in her analysis that Shooting Star Gun Club did offer a safety course, then the receiver of that course, in this case, Justice Carbo, would have been able to learn the proper operation of the firearm because of that course.
Your Honor, as I just previously said, she is not the tenure as an expert in firearm safety, therefore, she can't provide an expert opinion on the safe nature of the course or the best safety practices in the firearm industry.
I'm gonna overrule objection.
Yes, Your Honor.
Ms. Staub, would you like me to repeat my question? So based on your analysis, what did you best attribute the cause of the incident on May 28th to? I consider that the cause of the incident was due to the overly sensitive trigger of the gun. Thank you, Your Honor. There are no further questions at this time.
I'm not sure.
No, Your Honor, she could take it on.
She can do it.
Yes. Good morning, Ms. Staub. I'd like to start by discussing what you do and what you don't blame for the shoot. You don't blame my client, Justice Carbo, at all for getting shot at the defendant's gun range, do you?
No, I am not assigned blame to any particular person or party in my analysis. As I was confronted with conflicting testimony, I was not able to come to a conclusion, and I chose not to come to a conclusion on whether the fault lied on either party, and instead focus on where my expertise lies on the gun itself and its operation.
So if the defense attorneys attempt to blame my client in any way, you would disagree with them?
Well, not particularly, because I have not come to a conclusion on this, and I feel uncomfortable on coming to a conclusion on this. And based on the materials I reviewed, I was not able to come to a conclusion.
You wouldn't blame, so it's your testimony, you would blame my client for the shooting?
That is not what I think.
Regardless, it's your opinion that the gun itself is the blame to this incident, right?
Yes, I consider that one of the potential causes of this fire was the overly sensitive trigger of the hand.
Instead of blaming the human operating the firearm, you actually put the blame on the gun itself. That's right.
Because of the conflicting testimonies I was confronted with, I chose to make a conclusion on the gun itself, and through my personal examination of the gun, this conclusion is what I found.
Right, more specifically, the overly sensitive trigger was the most likely cause for the second gunshot, right?
Yes, based on the evidence I was able to use that as the conclusion I was making.
Well, I'd like to talk about that gun in more detail. Mr. Cantrell shot my client while demonstrating with a Glock 22, right?
That's right.
A Glock 22 is a firearm that's suitable for novices. Do you agree with that?
Yes, I would.
So since it's suitable for novices, a competent firearm safety instructor should know how to safely handle a Glock 22.
Well, my expertise lies in the mechanics of operation, so I will not testify to whether the operator is safely handling the gun.
Based on your reasoning, a competent firearm safety instructor should not lose control of the Glock 22.
Objection, improper opinion. May I elaborate?
Please.
This question calls for my witness to understand the industry practices of a firearm safety instructor and what is best practice for an individual of that nature. And since she has been entered in an expert in firearms mechanics and operation, which is where her expertise lies, it would be improper for her to come to a conclusion on this question as she previously stated.
Your Honor, I'm asking Ms. Staub to provide an expert opinion on how a firearm safety instructor should operate with the Glock 22. As I've previously established, it's a gun that's suitable for novices.
But you're arguing that about the gun safety operation, about the actual instructor, right? And the question points to that, right?
Yes, Your Honor, it goes to the operability of the firearm by a firearm safety instructor.
Little too thin, I'm going to sustain the objection.
Thank you, Your Honor.
Now, Ms. Staub, this told the jury, the Glock 22 that you examined in this case had an overly sensitive trigger. But isn't it true that all Glock 22s are known for having a lighter trigger pull?
Well, while Glock 22 as a whole are known to have a lighter trigger, through my personal examination of this story, I found that this trigger was in fact different from even other Glock 22.
Is your testimony that this Glock 22 was different than any other Glock 22?
It had a lighter recoil than other Glock.
Ms. Staub, you have no test results to back this claim, do you?
While I have not conducted any tests regarding the gun, through my personal examination handling of said gun, I was able to reach the conclusions that I presented in front of you today.
You have no data to objectively prove your claim that this Glock 22 had an overly sensitive trigger.
Yes, while I have no empirics to show the court today, through my personal examination of the gun as an expert, I found that this gun has a laser trigger.
So regardless of whether you say this Glock 22 had a sensitive trigger, it was still aimed at my client's leg when it shot him. That's right.
No, that's not quite correct. From the affidavits and depositions that I reviewed, Mr. Cantrell was pointing the gun towards where he was supposed to at the target. And during the shot, something changed within the handling of the gun, and that directed him to shoot Mr. Carter.
Somehow the gun ended up in a direction where it was able to shoot my client in the leg. That's right.
Yes, somehow in that situation that happened.
Now, Ms. Staub, as a part of your work in this case, you read the sworn statement of Drew Cantrell, right?
Yes, I did.
So you're aware that Mr. Cantrell claims that the gun recoil was more violent than any other recoil he's ever had before, right?
Yes, yes, I did that.
And that unexpectedly violent recoil redirected the firearm back and to the right, right?
That's right.
And back and to the right, exactly where Mr. Cantrell told my client to stand, right?
No, Mr. Cantrell told this car to stand directly to his right.
To the right, that's right.
Yes.
And would you say, Ms. Staub, that the unexpectedly violent recoil created an unsafe condition, right?
Again, I've been entered as an expert in firearms operation and mechanics and will not testify to the safety of the operation.
That's fine, Ms. Staub. Now, the truth is, Ms. Staub, is that Mr. Cantrell would have learned about the violent recoil had she simply followed shooting stars from safety rules, right? Yes, ma'am. It's true that Mr. Cantrell would have learned about the violent recoil had she simply followed shooting stars, right?
Well, from what I understood from the affidavit and deposition that I reviewed, Mr. Cantrell found that this recoil was different from other guns, so he would not have learned about whether he would not know this prior to firing the gun.
Well, let's talk about those rules. I'd like to turn your attention to, exhibit 8. Oh, and you're fine. I'd like to turn specifically to Rule 7. It says, always make sure your weapon is functioning correctly, properly cleaned, and safe to use. That's right.
Yes, that's what it is.
Always is an absolute, and at least no room for leeway.
Objection, Your Honor, improper opinion. Specifically, this witness testifying as to the meaning of the rules posted specifically inside of Shooting Star Gun Club's shooting range would be an improper testimony, as she is not a representative of Shooting Star Gun Club as its manager or as its CEO or even as the creator of these rules, and therefore cannot speak to exactly what the inherent meaning inside the wording of the document would be.
That's sustained. Councilman Chancellor, you pretty much.
Thank you.
Yes, John. Well, do you agree that the word always is an absolute, right?
According to the English language, yes.
And always, it always means that a firearm safety instructor should always check to assess their gun.
Objection, Your Honor. I re-raise my objection on improper opinion, specifically because these are rules posted inside of Shooting Star Gun Club's range. Therefore, my witness cannot speak to them.
Yes, John. Ms. Staub, like you said before, you agree that had Mr. Cantrell simply followed Shooting Star's rules, she would have learned about the violent recoil, right?
Objection, Your Honor. Again, improper opinion. My witness cannot testify as to what would have happened if this witness would have followed the rules posted inside Shooting Star Gun Club's range, specifically as they are written on that document, because I would assume the intent and the purpose of the rules that she is not aware of.
Respond to that.
Yes, Your Honor. I'm simply asking Ms. Staub to say, based on her reasoning as an expert in firearm operability, had Mr. Cantrell simply tested the firearm before, and she would have learned about the violent recoil before.
Fair question. Overruled.
Thank you, Your Honor.
And based on your reading of Mr. Cantrell's sworn statement, you're aware that Mr. Cantrell took the Glock 22 that my client had just purchased and took it directly to the range to cheat the course. That's right?
Yeah.
So she failed. She never assessed how that gun was functioning, right?
I believe that's correct. However, because I'm not aware of the direct role of a safety instructor in student programs specifically, that role could potentially include and not include this responsibility.
So she never assessed whether her gun was functioning correctly or safely. Right?
She did not, he did not test his gun prior to firing in gun range. That's correct.
And because Mr. Cantrell failed to follow Rule 7 here, she never learned about the violent recoil that ended up hitting my client, that caused the gun to shoot my client in the leg.
Objection, Your Honor. Improper opinion. My witness cannot speak to whether or not Mr. Cantrell followed this rule or not, and therefore cannot answer that question on that premise.
Okay, let's move this along. So she's an expert on gun mechanics. Any questions about gun mechanic, the aspect of the light trigger pull and all those things? Fair questions. Questions about what's happened before otherwise. I think I agree that it's outside the realm of the question. So let's try and move forward and focus on that.
Yes, sir. Ms. Donovan said, Ms. Cantrell never assessed this fire, right?
Before firing this particular weapon, I don't believe so based on that.
Mr. Cantrell was not aware of the violent recoil prior to demonstration, right?
Yes, and that will be partly why, as we stated, it's by product.
Thank you, Ms. Donovan. No further questions, John.
You're direct?
No, Your Honor.
Okay, what do you think? Thank you. I believe the defense rests, correct?
Yes, Your Honor, at this time, the defense rests, but before we proceed to closing arguments, may we please request a time check?
Yes, please. Thank you.
One moment, Your Honor.
Yeah, we'll get you. We're a good time.
Your Honor, I have for the plaintiff 6 minutes and 59 seconds remaining, and for the defense 12 minutes and 56 seconds remaining.
Your Honor, I have the same.
All right, let's take exactly 5 minutes. We're ready for cross-examination. We've got less time than that, but we're fine and all clear. I think 5 minutes is exactly what I'm gonna use and go goes on. But time for the parties?
Yes, Your Honor. Yes, Your Honor.
All right, 5 minute recess.
Yes.
Yeah. Hello. Hello.
Thank you. Your Honor, 5 minutes have elapsed.
Return to questions. The person goes by, so I'll walk out.
I can go grab that.
Yeah, as long as he gets here before he does.
Okay.
Well done. All right. Defense counsel ready to proceed?
Yes, Your Honor.
Defense ready to proceed?
Yes, Your Honor.
Get started. Defendants, sorry, counsel for, plaintiffs, you proceed to closing argument. Are you looking for a rebuttal time?
Yes, Your Honor. Could I reserve the remaining time I have for rebuttal?
Yes, sure.
Thank you. May it please the court, Mr. Kim. In members of this jury, all of the warning signs were there. That's what Mr. Miguel told you at the beginning of today's trial. And now you can see that he was correct. On May 28th of 2022, there were warning signs that Mr. Drew Cantrell was unfit to be a firearm safety instructor. You learned today that Mr. Cantrell was hired because he was simply good on the checkbook. He was hired because of money, because it was a financial decision. It was safety. And my client, Ms. Justice Fargo, paid the price. You also learned today that Ms. Justice Fargo watched the commercial that the defendant put on television. She was tricked. She was tricked into believing that they were the expert. Here's what jury you heard what she said on the witness stand. Shooting Star marketed that if you came to Shooting Star gun range, you'd be like wearing packing from Meryl Streep or basketball. for Michael Jordan. The only difference is that Meryl and Michael are not gonna shoot you in the way in the middle of your trains. Which is why Ms. Carbo has sued shooting star gun range for negligent retention and hiring of Mr. Drew Cantrell. Now, as the judge will instruct you, as the plaintiff, we have to prove that it's more likely true than not that Mr. Cantrell was unfit to be a firearms safety instructor, that shooting star knew or should have known that Mr. Cantrell was unfit. And lastly, we had to prove that the negligent retention and hiring of Mr. Cantrell resulted in my finding. Throughout the trial, we piloted 3 facts, all of which prove that we have better proof. Fact number 1, Mr. Cantrell was unfit to be a firearms safety instructor. Fact number 2, shooting star gun club knew or should have known that he was fit. And fact number 3, it still put a gun in the hands of Mr. Cantrell. Why? Now, I'll take each of these one at a time, starting with the first fact. That Mr. Cantrell was unfit to be a firearms safety instructor. You learned today that while he worked at Shooting Star Gun Range, he broke 2 safety rules. In May of 2021, he aimed a firearm at another coworker in the shop. And you learned in November of 2021, he broke another safety rule by taking a loaded gun out of the shooting range and into the circle, endangering everybody around him. You also learned that he was fired from his previous job for being drunk on the job. You heard our expert testimony from Dr. Judd, who said, in his expert opinion, Mr. Drew Cantrell was unfit to be a firearms safety instructor. And that brings me to the second fact, that Shooting Star knew and should have known that Mr. Cantrell wasn't fit. There are 2 things that they knew, and there's one that they should have. The 2 things are both of the incidents in May of 2021 and November of 2021. We know this because Mr. Coleman, the owner of Shooting Star Gun Range, wrote up Mr. Cantrell for both of those incidents and formally. You heard Mr. Hernandez say that he heard Mr. Coleman chat something Drew Cantrell for breaking yet another safety rule. Shooting Star knew that he breaks safety. One thing they did is that he had been fired from his previous job for being drunk on the job. And why? Mr. Coleman never asked God to left that. Fact number 3. They still put the gun in the hands of Mr. Cantrell. But why? Because it was a financial decision. What the defense counsel didn't tell you is that Shooting Star had just lost their previous firearms safety instructor, and Mr. Coleman was in need of filling the spot. And when Mr. Cantrell came in looking for a position, Mr. Coleman himself said, it wasn't bad on the check. He didn't hire Mr. Cantrell because he needed a safety instructor for safety purposes. He hired Mr. Cantrell because he needed to fill a spot that it didn't. Like that brings me to my last point. Mr. Cantrell's pattern of breaking safety rule after safety rule was predictable. And just as predictable as it was, he violated yet another safety rule on May 28th of 2022. You learned today that he took my client's brand new Glock 22 off the counter and straight into the range and began teaching a training. That violates Rule 7 of Shooting Star Rule. You have to test if every gun is functioning correctly before you use it. Dr. Staub, their own expert, said that she believed it was the gun misfired that caused Mr. Carbo's injury and that no human was to blame. Members of the jury, if Mr. Cantrell had test fired that gun before just bringing it into the range and beginning the training session, he would have known about the overly sensitive trigger, and he would have known about the whole trigger. And none of this would have happened if it weren't for him breaking yet another safety rule. The title was predictable. You cannot expect to be safe if you choose to violate safety rules. In your better judgment, to understand that he has violated safety rule after safety rule after safety rule, the problem is that he failed to check it and defended sitting there. For these reasons, we ask you to find the defendant liable for negative representation and silence of this abuse candidate. All the right signs for that.
Thank you, counsel. How much time during?
1 minute,
1 minute or 1 minute?
1 minute, 1 second.
That's when you're ready to do it.
Your Honor, Your Honor, before I proceed with my speech, may I please ask my timekeeper to redirect themselves so that I can see the time cards clearly?
I have no problem.
Thank you, Your Honor. More specifically, we request Mr. Donovan to sit at the
Witness, yes. Move the chair, we go down. What's up? See when you're ready.
Your Honor, members of the jury, opposing counsel, may it please the court. You can expect to learn if you choose not to listen. On May 28th, Justice Cargo, like any other customer, came into Shooting Star to learn how to safely operate her new gun. But unlike any other customer, she chose not to listen to the advertisement, to Mr. Coleman's email, to the liability waiver. And during that safety course, she also chose not to listen to her own instructor's direction. That is why we are here today. Now, we can all sympathize with Ms. Harbo's injury, but today we must move past the emotions we feel and turn to the facts. Because today is if the evidence is proved by hundreds of the evidence that Shooting Star acted negligently and recklessly sold or entrusted a firearm. Now, members of the jury, when examining negligence in this jurisdiction, you must look at what a reasonable person, what a reasonable business would do, the industry standard. So let's break down each and every one of the points of negligence that the plaintiff must do. Firstly, they must prove that Shooting Star hired Drew Cantrell. Now, members of the jury, that point isn't in contention, and in fact, the evidence proves that Shooting Star met the industry standard for their hiring practices. When Mr. Coleman was first interviewing Drew Cantrell, he ascertained a specific skill set relevant to the job that he would be doing. Then, when Mr. Cantrell wanted a promotion, he explicitly required more certification. That is the industry standard. He didn't give the job willy-nilly. He didn't give the job because of the money. No, he gave the job because Drew Cantrell was qualified. Second, they must establish that Drew Cantrell became unfit to do the work that he was hired for. Well, to do this, they brought up two incidents. Well, members of the jury, the law flourishes in specificity. Rules exist for a reason, and in Exhibit 8, the rules are specifically listed as for the gun safety range. Members of the jury, the rules that Mr. Cantrell wrote weren't applicable in this case. They had no incident happened outside of the gun range, and not from you actually teaching the courts. Prior to May 28th, Drew Cantrell had never had an incident inside the gun range, teaching the course to other students. Third, they must establish that Shooting Star knew or should have known that Drew Cantrell became unfit, and that incompetence created a particular risk to others. Well, if we've already proven that Drew Cantrell was never unfit, there was no incompetence, and there was no risk to others. But beyond that, you heard today from Drew Cantrell, from Avery Lewis, and from the plaintiff's own Ross Hernandez about how heavy-handed Skylar Coleman was in their reprimand. Skylar Coleman ran a tight ship. If there was any aspect of incompetence, it'd be nipped in the bud before it could fall away. And that's exactly what happened. Skylar Coleman properly reprimanded Drew Cantrell, and he learned from those mistakes, never repeating them and never having a single other incident after November. Fourth, we must establish that Drew Cantrell's unfitness harmed Justice Harbaugh. Well, members of the jury, until May 28th, Drew Cantrell had taught the class done hundreds of times with no issue. Why? Because he had students who listened to his direction with no issue. That is the deciding factor. On May 28th, Justice Harbaugh chose not to listen. You saw today where Justice Harbaugh was positioned at the time of the incident. Sort of to the right, not straight to the right, as Mr. Cantrell's specific and simple instructions dictate. Because of that, when Justice Harbaugh flinched at the initial first shot and bumped into Drew Cantrell, that is what led to the second shot. Finally, it was established that shooting star negligent hiring and retention of Drew Cantrell was a direct and proximate cause of Justice Harbaugh's harm. Well, members of the jury, we've already proven to you today that, firstly, Skylar Coleman followed all of the proper industry standards for hiring and retaining employees. And we've also proven to you that Justice Harbaugh was the cause of the accident on May 28th, not Drew Cantrell. Today, the defense has thoroughly disestablished their claim. Now, today, you've heard opposing counsel mention those 3 points, but those 3 points never related to the second charge that they took on the burden to prove: reckless sale or entrustment of the firearm. Firstly, they must establish that shooting star improperly sold or entrusted a firearm. Well, when they were selling a gun to Justice Harbaugh, they followed the government standard to the literal dotted line. They provided him a background check with specific forms that all constitute the industry standard. When they were entrusting the gun to Drew Cantrell, this was only after he had proven that he could properly handle them. He wasn't allowed to handle guns in the range when he was a sales clerk. No, it required more certification. And he got that in the form of his safety instructor certificate on top of his safety gun license. Now that safety gun license is the same one the plaintiff's own expert witness owned. Keep that in mind. Second, they must prove that Justice Harbaugh and Drew Cantrell were unfit to own firearms. Well, let's look at the actions of shooting star on May 28th. Before Justice Harbaugh was allowed to leave the gun or leave the shop with the gun in their hand, they had to go through a safety course. That safety course would have thoroughly prepared them had the accident not happened, had Justice Harbaugh chose to listen. Shooting star didn't. It was opposite of recklessness. Secondly, Mr. Cantrell was indeed fit to own a gun. You heard today from Jackie Stahl that he handled everything perfectly in terms of mechanics and operation. You heard Mr. Cantrell's testimony that he had years of experience handling guns. May 28th was no different. He didn't suddenly lose or forget all of his knowledge. No, all he was dealing with was someone who chose not to listen. Finally, they must prove that shooting star's reckless sale or entrustment of a firearm was a direct and proximate cause for Justice Harbaugh harm. Well, today we've already proven to you very clearly that what happened on May 28th was beyond shooting star's control. Could they have known that Justice Harbaugh would disregard simple instructions when they sold her the gun? No. Could they have ascertained that when they were hiring Drew Cantrell? No. The sale and entrustment of the gun was not reckless and therefore could not have influenced what happened on May 28th. Again, we've broken the defensive. Now, even if members of the jury, you're still holding on to some aspect of shooting star or Drew Cantrell acting negligently, that will be severed with the presentation of our affirmative defenses. Members of the jury, if we prove any one of our affirmative defenses today, then you cannot find shooting star negligence. The commercial and liability waivers represent our first affirmative defense assumption of race. We must prove by preponderance of the evidence the same degree that the plaintiff has, more likely than not, that one, Justice Carbo knew of the risk of injury associated with the gun range, and two, voluntarily proceeded in the face of that risk. Well, let's look at the commercial and the liability waiver today. You heard testimony that Drew Cantrell heard the commercial. This was the first thing he saw before his accident. And what did the commercial say? Customers assume all risks and responsibilities associated with firearms, the ownership and usage. And you also heard Ms. Carbo testifying to her signing the liability waiver, the last thing she saw before her accident. I'm fully aware of the risks and hazards connected with being on the premises, in the gun range, and I hereby elect to voluntarily participate in the gun range. Members of the jury, it's a textbook assumption of risk. Now, although we've clearly proven assumption of risk, we've gone even further. We've established superseding and intervening causation. To put it simply, if there were factors beyond shooting star control on May 28th, that severs the chain of causation that has been said wrong. And you heard both of the expert witnesses agree to that statement. Jackie Scott testified today that the Glock 22 had an insanely, an unpredictably light trigger, different from what the norm was. And you also heard Dr. Judd testify that Drew Cantrell's situation was only heightened in risk because of where Judd chose to stand. Your Honor, members of the jury, opposing counsel, could shooting star have controlled where Justice Carbo chose to stand? No. Drew Cantrell operated under the assumption that Justice Carbo would do the bare minimum of listening to your own teacher's instructions when you are in gun knowledge. But she didn't. That is what caused everything. Now, in evaluating the totality of the circumstances and the totality of the evidence today, it's important to understand beautiful. It's key to understand beautiful. And who has a place to call through all of the charges? One eyewitness, Justice Carbo. Someone who doesn't know anything about how shooting star normally operates, someone who can't follow basic directions, and also someone who's concerned about the mind. You've heard opposing counsel try to argue that Mr. Coleman only hired Drew Cantrell because it was good for the checkbook. We've already established that. It wasn't because of the checkbook, it was because of his credentials. Compare that to Justice Carbo. You heard her today admit that she intends to take every single penny she can from shooting star after a $20 million settlement. What else is there to say? Now, compare that to who we have called. Two eyewitnesses. A seasoned instructor, someone who's never had an accident inside the safety room. And a shooting star regular, someone borderline on a gun expert from all their experience handling and experimenting with guns. They didn't way. They gave you the more accurate, the more true, the more trustworthy interpretation of what happened on May 28th. It was free, their testimonies were free from the biases of incompetence or ignorance. Your Honor, members of the jury, you can't expect to learn if you choose not to listen. Now, you've heard both counsel try to bring up the fact that the warning signs were all there, and we agree with that. The warning signs were all there. Justice Carbo knew that the shooting star involved guns, and that guns are dangerous, and that the gun range is dangerous. And despite that, she chose not to listen. And today, members of the jury, I trust you to have listened to all the experts witnesses, to all the lay witnesses, to all the testimonies, to all the evidence brought today, to learn once and for all that shooting stars should not be held liable on all charges. Thank you.
Please, counsel. Might want to see the remote.
Yes, Your Honor.
See when you're ready.
Mr. Cantrell was certified, not qualified, and we see that because he consistently broke safety rules. As a reasonable person would, and no reasonable employer would retain them or hire them if they knew that they had a tendency to break safety. Dr. Slum herself said that it was the gun's fault that it was happening. If Mr. Cantrell had simply followed safety rules, he would have tested that gun before taking my client off the range, and none of this would happen. And secondly, to bring up the assumption of the risk that they brought, members of the jury, this is not a magical sheet of paper. This sheet of paper is not borrowed from them. And the judge will tell you that after
independent filing. Thank you.
All right, thank you guys so much for the presentation today. We're gonna take a little time for the jurors and myself to catch up on scoring. Let's stay in character. I think we should all be good at bathroom breaks for the next few minutes to finish scoring. Let's have a wrap up and get out of here sometime.